Thank you very much for tuning into this session. I'm always somewhat surprised that this subject is still one which gives rise to concern. And I thought that some years ago that we had hit most of the problems on the head. But I also run a number of advice centres for parish clerks and others. And I'm quite surprised to find that these questions which I'm about to address come up on numerous occasions. So I will talk about them again. My wife gets very upset with me because every time we go around the country and stay anywhere, the immediate thing that I do is to go and have a look at the parish or town council notice board to see what's going on, what the agenda is, what the notices are there. And I am always quite amazed at the number of different types of notice which are put up by clerks. I basically talked to a clerk the other day as to why one clerk had actually put up more than one notice. And I was told, well, she felt extremely uncomfortable about putting a notice up to summons people to a meeting. So therefore she put up an invitation to the public and also a summons to the councillors. Well, it's all very well to be that concerned about matters, but in fact the law says that people should be summoned to a meeting, and it is necessary to use that expression. I haven't had a case yet of somebody saying it's unlawful if you don't summons councillors in particular to a meeting, but with so many public-spirited people around these days, it's probably not very long before somebody will pick up that particular point. So again, I emphasise that it is a summons to the meeting. It's a summons to the meeting which has to be signed by the proper officer of the council, unless it is an extraordinary meeting which is called by two councillors, when they have to sign the notice of meeting and also the agenda. But otherwise, it's the proper officer of the council. And if the proper officer is not available, strictly speaking, it's still signed in their or summonsed in their name until such time as they resign. We've had a couple of cases recently where proper officers have stepped aside for a period, and then in those circumstances it's probably all right for the assistant or deputy to sign, but generally speaking it has to be the proper officer. Must be sent to each councillor. Again, you can't miss out any councillors that you don't like, although I have known at least one case of that. It can be by email if the councillor has indicated that they're prepared to receive it by email. You will find that, as I say, that is the way of doing it. Once you've done that, you have legitimately called your meeting, or it doesn't matter whether it's I hereby summons, or normally people put councillors. Councillors are summoned to a meeting. There are a couple of questions coming up which I will look at in the chat when we come to Q&A session. So basically, that is how it is to be done. That's what the law says, the 1972 Act says. We all know that that Act is now a bit out of date, but until such time as it is reformed, then that's what you should be doing. Summonsing councils, you can invite other people to it if you want to. Electronic signature, it doesn't have to be your normal and should not be your normal signature. In fact, printing the name is in law a signature. So you don't use your normal signature because there are too many people around who use signatures. These days you have to have more than one signature for various purposes. So it's interesting then, if you get forged documents, you can usually trace back where they've come from if you've used signatures for particular purposes. I had one of those cases recently where I used one signature for something and another one for something else, and the check which turned up was signed in one particular form. As far as I'll come on to minutes in a minute. The agenda, in fact, there is one other particular point that I will deal with, which is not strictly within what I'm supposed to be talking about, but a lot of councils these days are concerned about addresses for councils. And if you go onto websites of councils, which we do on a regular basis, because we have to check up that it's a legitimate council, very few councils actually now have a postal address. Now, in strictness, you should have an address for the council. And if any legal proceedings are to be served on the council, the law as it states at the moment states that it should be served on an address for the council. And that is normally interpreted as a postal address. If you've got an electronic address, then that's not necessarily sufficient to meet the legal requirements. Obviously, if you get the papers and acknowledgement, there's no question over service. But it is there is a requirement that there should be an address for service. You don't have to put it on every document, but it has to go on your website and must be available. So do have to think about that. PO Box does count as an address, provided that you do actually monitor the PO Box, and a number of councillors do have that. It's not necessarily an address which people need to visit, but it is actually an address which people can send things to, particularly legal documents. So please do consider that. Yes, the clerk's address is acceptable because that is the official address of the council. It has to be an address which is traceable. We have one or two councils that have decided that they're going to make the local church as their official address. Well, where it goes and who picks it up, I don't know. This is a problem for those clerks that work at home, because obviously a lot of them do not want their home address publicised. But as I say, in that case, a lot of people do it by virtue of a PO box or something similar, as long as these are monitored on a regular basis. Because one of the problems is that documents have to be acknowledged or otherwise within a short space of time. So if you don't go to the PO box or the local post office or wherever the address is for long periods of time, you could find that you are out of time. The land registry now accepts an email address as an additional address for a parish council, but unfortunately some councils change their email addresses on a regular basis as well, and that doesn't help. It's a question of keeping it up to date as far as the address is concerned. As I say, that is slightly off my subject, but it is one of my bugbears at the moment. Agenda must form part of the summons and specify the business which the meeting is to transact, and is the primary responsibility of the clerk. That does not mean that councillors can't suggest things, or the chairman can't suggest things either. You can be very dictatorial and say, no way, that you are not going to allow any items on, but the ultimate is the clerk is responsible for the agenda. If there is an item for apologies for absence, which there should be, it is necessary when notice of absence is given that there are reasons stated. There is concern that if you say I'm going away for 6 months to Puerto Rico or something like that, doesn't have to be specific, but the law states that if there is a reason given for absence, it has to be accepted by the council. And if it is not accepted, then the old 6-month rule that is a 6-month rule, which can be that they are actually disqualified. So it needs to be some form of reason which is acceptable, and not just because they don't want to turn up. A blanket decision that you will not accept any apologies for absence is, in our view, not permitted. We have 1 or 2 councils where they want to get rid of councillors, and basically they are using a decision that they won't accept any apologies. As I say, some reason has to be given. It doesn't have to be very explicit, but it does have to be, you can invent whatever it is, but you must have some sort of reason. Now, agenda items must be framed in such a way that the people who are going to discuss it understand what is going on and what sort of decision the council is expected to come to. So therefore, it should not be an item which is obscure, so that basically you can generally understand what's going on, and that you will be expected to make a decision. Because the council cannot lawfully make a decision on an item which is not on the agenda. There are several questions coming up at the moment. One is that if apologies are accepted, then the 6-month rule does not apply. That is correct. The 6-month rule only applies if there are absences which the council does not accept. Then you will find then that the 6-month rule starts to run. So if you have a councillor that gives apologies for 1 meeting and then is absent for the next several meetings, the first meeting that starts the 6-month period running is the one after apologies are accepted. It can be general, as you say, it can be illness. If there are no apologies given, then the 6-month rule starts to apply. So the clock starts ticking. Again, the old favourite of any other business should not appear on the agenda, because it is not something which you can make a decision on. As far as that item is concerned, it's not on the agenda. Some people want something on the agenda which enables people to have a discussion about things which have arisen since the last parish council meeting. That is fine. You can have a general report. Then you will find that you can then have a discussion, but you can't take a decision on that particular item. So if it comes up, there are overhanging bushes on a particular footpath, then the council cannot actually decide at that particular time that they will incur the cost of cutting it back. So therefore you can't take any decisions which do not relate to items which are specifically on the agenda. But you can have a general discussion and a decision can be taken at a later stage, or if necessary, a decision could be referred to a subcommittee. I will deal with the questions which are coming fast and furious in a minute. So I will deal with it then. The minutes are a formal record of the meeting, and once signed are admissible as evidence of what happened at that meeting. Minutes should be a record of the decisions taken. They should not be verbatim. They should be a record of the decisions only. If the councillors ask for a recorded vote, then the votes for and against can be recorded. If not, there is no need to do so. It is assumed that they are passed by a majority. As far as that's concerned, that would be sufficient for evidence. Once the minutes have been approved, they are legal proof. They cannot be altered. Now, it may be that if something is very wrong, then you may have to have a discussion about it and a resolution until a resolution to clarify the previous minutes, that the previous minutes stand. They cannot be altered. As I say, we've had a number of requests recently where people have asked for their names to be removed from previous minutes. This is not possible. So that basically, once it's there, it records who is at the meeting, and as I say, it records apologies for absence, which can, as I say, just say reasons given and accepted, as far as that's concerned. So you will find, therefore, that you cannot go backwards, you can go forward. Originally, minutes were kept in bound volumes, and I was surprised a couple of weeks ago to be asked by a council whether it was still necessary for them to handwrite the minutes in a bound volume. When I said no, it wasn't necessary, they said, oh, well, how are we going to continue? Because we've got so many bound volumes anyway, but it's not necessarily for them written. So basically, once they're in that minute book, then they are the minutes. If they are not in a bound book, which most aren't these days, they have to be numbered or some other identification so that it can be seen that they are not likely to be tampered with or any additions made. So the whole point about it is that once it's approved, it is that is the legal decisions of the council. It cannot be altered as such. As I say, there's no need to record votes unless requested. The minutes are signed at the next meeting. Now, as far as the annual parish meeting is concerned, then they are signed at the next parish meeting. You don't wait for a year to sign the minutes. They can be signed at the next meeting of the parish council or the next parish meeting. So that is, once they're signed, that's it. They're not exactly written in stone, but you can't make any changes. I am aware of lots of questions and lots of things in the chat. So what I think I probably will do, I've got a number in the question and answer session, and then we'll look at the chat. Angela has asked, how do you deal with minutes that defame and libel individuals? You shouldn't have minutes that do that. All you are doing is making a note of the decision, not the discussion of the meeting. So therefore, you shouldn't have any minutes that defame and libel individuals. And you should deliberately not include anything of that nature. How far should chairs and clerks collaborate over what goes into the minutes? The taking of the minutes is the responsibility of the clerk, and there should be no other input other than possibly a clarification. So therefore, it is for the clerk to take an accurate record of the decision of the meeting. And if they are not satisfied as to exactly what decision was taken, and as the chairman of a parish council and a member for many years, I know that situation arises, then they need to seek clarification at that time. And if necessary, the whole thing should be, the meeting should be stopped while it is actually written out. Angela, again, she's on about slanders and defamatory thing. As I say, the actual minutes are a record of the meeting, not other information should not be included on those minutes. So you shouldn't even have a situation where untrue and defamatory matters are in the minutes themselves. Alexandra has asked whether it's all right to give an hour notice to peruse with no other site or not. Well, the agenda is sent out with the summons for the meeting. So therefore, every councillor, having been summoned to the meeting, should have details of the agenda items, and they are entitled to that. I've got hundreds of things in the chat, so I don't think I'll go through some of them and see if there is anything which once an agenda has gone out, should it be added to? No. That is what the meeting has been summoned for. They're coming in thick and fast. Do you have to minute what district and county councils? Not necessarily. Sometimes you say that the councillor said something which is of interest to the area, but you don't necessarily have to minute because it's a report. It is not something which is actually a decision of the council. It's a report only. Does the clerk have to issue a summons agenda to committee meetings? It is good practice to do so because it is a formal meeting of a branch of the council. They don't have to clerk that meeting themselves or take the minutes, but it is really for them to send it out because they have to have a complete knowledge of what is going on in their council and what the committee are going to be discussing. What about working parties? Well, the situation is, as you know, now takes the view that there shouldn't be working parties. We take the view that a working party is in order if it is basically a discussion group about a project or something which the council is contemplating and upon which no decision will be taken. So in other words, if there is a proposal that there should be a market fair on Easter Sunday, it is quite useful to have informal discussions as to who's likely to attend, who is going to turn up, and all the rest of it. That could be a working party. Once it comes to a decision time, it either goes to a committee or to the council itself. Yes, they're coming so thick and fast that basically I only deal with the ones that are at the bottom. I haven't got any further. as a committee chair, can I be given half an hour to produce a draft agenda? Well, yes. I mean, you can ask to see the draft agenda, and you can make proposals to it. The timing of that is something which you need to discuss with the clerk. Can committees make decisions or only recommendations? Depends on their terms of reference. Most committees have some way of making decisions which have been delegated to them, but a lot of committees have to make a decision within that committee and then refer that decision for a final decision to the council itself. Proxy vote on an agenda item. In England, no, you can't have a proxy vote for councillors. If a councillor does have long-term sickness and give apologies which are accepted, that is in order. It is, apologies have to be given and they have to be accepted. The 6 months runs when either no apologies are given or apologies are not accepted. Now, I know that some people do take the view that the 6 months runs even without, even if apologies are given, but the answer is that is incorrect. Once apologies are given and accepted as such, then the 6 month period does not start to run. And do remember that once the 6 month period has expired, then that councillor is automatically disqualified. They can't be resuscitated. The vacancy occurs the moment the clock ticks up to the end of the 6 month, and you're stuck with having to is basically having to declare a vacancy. You would not necessarily, I've been asked about typing names of the public. I would not do that. I do not see that there is any necessity to name members of the public in minutes, so I would not do so. You can say a member of the public raised, but I would not identify them in what is basically a public document. Decisions made on planning applications, not the agenda. Generally speaking, no. Again, whether it's a committee or otherwise, you should not make a decision on things which are not on the agenda. There are circumstances where it would be possible to have it out. Basically, well, you can't take a decision on it. Let's not complicate it. You can't take a decision on it if it's not on the agenda. You should have a procedure if a planning application comes in between committee meetings as to what actually happens, whether the committee is convened or what, or whether in fact it is an important planning application. If it is for a substantial development, you would want to hold a special meeting. So that's what you want to do. Do you have to minute who proposed and seconded a motion? There is no need to say who seconded a motion. The motion is proposed. There is actually no provision for it to be seconded, although it's normal to do so, but it doesn't have to be stated because under the law, the motion has to be proposed. So that that's what. Do hard copies of minutes need to be kept, or can scanned copies be kept? The answer is it is still preferable to have hard copies. You are supposed to keep them for entire period. And if you have got a lot of minutes, you should send them to the local county record office for keeping, so that people can be signposted to that if they want old minutes. You can't destroy minutes, you can't dispose of them, or you shouldn't do, and so therefore they need to be kept, and sending them to the county record office or history society or history centre, sorry, is the best way of dealing with it. As far as what wording would you recommend for decisions? Proposed. It was proposed and the motion was passed, and it was resolved. Whatever wording that you do. Do you need to bind minutes before sending? Have a word with the county record office. They will tell you what they want as far as that's concerned. So basically, the unitary authority won't take minutes. Find somebody that will, but you can't, or safe storage or something, maybe even the county office next door. You need to have some, you can't destroy them or get rid of them. I have exceeded my time, I think. And as can be seen, which is usual with my talks, that basically go on forever. I had one the other night which was scheduled for an hour and went on for 2.5 hours, but never mind, I am loquacious. So in order to keep to your timetable, thank you very much for listening to me. Thank you for all the questions, and have a best rest of session.